Friends, welcome to the 129th session of Legal Empowerment through Interaction Lecture Series. The journey continues. We have been exposed to different thoughts, radical and otherwise. Today, we are sure that we'll be interacting with a wonderful personality, a wonderful judge, and the way in which we are going to address a topic on this platform. We'll just leave open to Madan Lokur, sir. But before that, I would like to thank Raman, sir. Thank you very much, sir, for getting this wonderful speaker onto this platform, and Vijay. And thank you for your presence, Ramkumar, sir, Ramakrishnan, sir, Call, sir, and all of you wonderful participants. The concept of locus standi has been diluted by the courts, and pill and sal had come into vogue. But nowadays, maybe because it's being misused, constraints and restraints are being imposed, and at times when you come with a public interest litigation, it's very difficult. Questions uncomfortable to a certain extent are being asked. But I believe today we'll have a wonderful session on public interest litigation and its parameters and contours. Over to you, sir.
Yeah, thank you. Thank you very much. And I think it's a great pleasure that I've been invited to this 129th lecture. I will be speaking about the necessity of checks and balances to public interest litigation. What I'm proposing to do is, to divide my talk into two different sections. The first section is going to be about public interest litigation generally. Right, what is the value of public interest litigation and how it has been developing, and what are the pitfalls, what are the advantages of public interest litigation in the context of social justice, because I believe public interest litigation is really a social justice litigation, or social action litigation, as Professor Upendra Bakshi likes to call it. The second part is going to be I will be dealing with some issues where the judiciary has come in for criticism on public interest litigation. Judicial activism, overreaching, and so on and so forth. But this really ties up with the first part as well. Now, you see, social justice is mentioned in the Constitution. We all know that it's mentioned in the preamble. Justice, social, economic, and political. We all know that. But how do you define social justice? People have written books on what is social justice. People have written articles. There is a mention about social justice in several judgments that have been delivered by eminent judges of the Supreme Court from time to time. Right from the 1960s, 70s, they mentioned social justice in some form or the other. But nobody has really sought to define it, and I don't think it can actually be defined. But as far as I'm concerned, if I was to look at social justice in the context of public interest litigation, I would say that social justice is the concept of social justice is to bring about equality amongst everybody, all sections of society, whether they're rich or poor, whatever religion they belong to, whatever caste they belong to, whatever creed, whatever race, it is equality. And through this process of equality, to bring about a dignity of life, which is, I think, central to Article 21 of the Constitution, because ultimately, whenever we talk about the right to life and animal existence, dignity comes into the picture. I mean, you can't say that, well, you can live like an animal as long as you get the right to life. I don't think that's an answer. Even that life has to be a life of dignity. Now, we have fundamental freedoms that are given to us in Article 19 of the Constitution. And all of them are in some form or the other aspects of social justice. Freedom of speech and expression. Everybody has the freedom of speech and expression. Just because I belong to a particular caste or I belong to a particular community, it doesn't mean that my freedom of speech or my freedom of expression is less than yours because you belong to a different caste or a different religion or a different community. It's the same. Similarly, freedom of movement. It is not dependent upon a person's predilections or caste, race, and so on and so forth. So really, fundamental freedoms guaranteed by Article 19 are an important aspect of equality, which is of course enshrined, as you all know, in Article 14, but is also a part of social justice. Notwithstanding this, uh, the Constituent Assembly has made certain privileges or rights or permissions that have been given under the Constitution to make special laws for women and children, for members of scheduled castes and scheduled tribes. I think it is, due to historical reasons. Women did not have the equality that all of us, talk about, and perhaps to encourage women to become equal to men, the Constituent Assembly permitted that special laws to be made for them. Children, of course, had no voice prior to independence. I think even today, children don't have much of a voice. But the idea is to have special laws for them so that they are equal to all of us. Similarly, for scheduled castes and scheduled tribes. But over the years, if you go back, to 1950 when the Constitution came, or even 1947 after we got independence, many of these rights, we are beginning to see them fructify into a form of equality only now. You see, now, sometime last month, the Supreme Court gave a judgment on the right to property of women. Now, it has taken 70 years for that to happen. Today, we are still struggling with intercaste marriages. People are getting killed if there's an intercaste marriage. People are getting killed if there is an interreligious marriage. So these are, social movements which have not actually taken off, so to speak, even though 70 years have gone by from the time we gained independence and 70 years from the time that we got our constitution. So really, all these are, a part of a process of development. These changes cannot happen overnight. You can't bring about equality overnight. But public interest litigation helps us to look into that and develop our society towards an egalitarian society, towards a society which is where everybody is equal and where everybody is in a position to live a life of dignity. Now, I have mentioned about women, children, scheduled castes, scheduled tribes. Of course, they're there in the Constitution. But over the years, the Supreme Court began to recognize other groups that were disadvantaged. Smaller groups, in the sense, women are like 50%, children are like 50%, but smaller groups, the Supreme Court began to recognize them. For example, bonded labor. In the case of Bandhua Mukti Mocha, they said, well, that's a disadvantaged group. And if you're talking about access to justice, even a letter sent by Swami Agnivesh is good enough. We will entertain it, and we will look into the rights of bonded labor and see whether they live a life of dignity. And in spite of the fact that there is an abolition of Bonded Labor Act and so on, bonded labor is prohibited by our Constitution, Article 23, which prohibits begar. Begar is nothing but bonded labor. There was still bonded labor. Today also there is bonded labor in some parts of the country. So brick kiln workers, for example, they are more or less, working as bonded labor in many of them and in many parts of the country. So the Supreme Court began to expand this group, which required special attention. Bonded labor was one of them. Access to justice. How does bonded labor get access to justice? That's where the question of locus standi comes in. Who is Swami Agnivesh? He was not a bonded laborer, but the bonded laborers did not have access to justice. So the Supreme Court said, well, if you send us a letter, it raises a constitutional issue, it raises an issue of public interest, we will certainly look into it. Of course, they had the question of locus standi decided in the case of S.P. Gupta, which liberalized locus standi. But taking it to a letter, sent by Swami Agnivesh was a major step forward in access to justice. Then you had the Bhagalpur blindings, where the police put acid into the eyes of persons who were suspected to be criminals. They put needles into their eyes, blinded them. How are those people in Bihar who are given this kind of treatment by the police, how can they ever come to the court? Forget about Supreme Court, they can't even come to to the Patna High Court. But on the basis of a mention having been made, supported by a newspaper report, Supreme Court again said, all right, we're expanding locus standi, because why are we doing it? We're doing it for the benefit of the people. We're not doing it because we're trying to get power or jurisdiction over something that we don't have. But these are fundamental rights that the people have, whether they're bonded laborers, whether they're accused or criminals. They need to live a life of dignity. And then you had environmental issues coming up, where Masuri Hills, limestone quarrying was going on. It was creating a massive pollution in Dehradun, which was at a lower height. You had the Bhopal gas tragedy. How do you expect them to come to the courts? They're more interested in saving their life than coming to the courts for stopping massive environmental disaster. So gradually, these groups of persons who required justice, began expanding. My experience on the social justice bench in the Supreme Court has led me to conclude that number one, we must look at public interest litigation in a positive manner. Certain checks and balances I will come to a little later, but if we start with locus standi, let's look at locus standi in a broad manner. I would put the kind of cases that had come before the social justice bench into four different categories. The first category is, where a law exists but is not being implemented. Now, when you talk about checks and balances, you also have to talk about checks and balances on the executive. So Parliament has legislated. The executive is not implementing the law. Parliament is not going to implement the law. Supreme Court is not going to implement the law. Executive has to implement the law. If they don't do it, what happens to the theory of checks and balances? So I will give you examples. We have the Manrega Act. Under Manrega, the person who's unemployed, there's a guarantee of 100 days employment in a year. The wages have to be paid within 15 days. If the wages are not paid within 15 days, interest has to be paid on the amount due. Now, any number of people, first of all, did not reach 100 days. That's a separate matter. But what is more important is that they did not get their wages within 15 days. Now, who is responsible for that? It obviously has to be the executive. And when you talk about checks and balances, well, why is the executive not giving them their wages? We looked into the issue and we said that you have to pay them their wages. In many cases, many cases, wages were not paid for 2 months. What about the interest? Now these people, they said, as long as we get the principal, forget about the interest, otherwise we'll have to go and, fight for our interest and so on and so forth. Even for getting wages, they would have to, in some instances, pay to the person in charge, that you give a certificate that I have worked and so on. And that fellow takes a cut of 5% or whatever that percentage is. And then the wages are paid. You have food security. Again, a very, very important legislation. Many states did not have, a food security commission. The law requires that you have a food security commission, but many states said, no, we are going to select somebody, we are going to appoint somebody, we are going to nominate somebody, all kinds of excuses. Again, a check on the functioning of the executive. Why are you not appointing a food security commission? We had an instance of one particular state saying that, we have not appointed in the entire state. They said we could not find one scheduled caste person whom we could appoint. How does one believe that? That in the entire state, you can't find one scheduled caste person who can be nominated to the Food Security Commission. So it's a check on executive. You could call it an excess, due to non-implementation, but certainly you have another category of these kind of cases. You have the National Commission for the Protection of Child Rights. It was without a chairperson for about 18 or 20 months. There was no chairperson. How is that body going to function? It's a statutory body. They were just not appointing anybody. So when we asked them, why are you not appointing anybody? Oh, selection process is going on, this, that, and the other. And ultimately, after 18 or 20 months and pushes from the court, an appointment was made. You have the Right to Information Act. Appointments not being made. Even last year, 2019, January or February, Supreme Court passed an order saying that why don't you appoint people to the Central Information Commission? Even today, there are vacancies. Supreme Court, government said yes. We will make the appointments. To some extent, they made some 1 or 2 appointments, maybe 3 appointments, but there have been retirements after that. So the theory of checks and balances, cannot apply only to the judiciary. You can't say that only the judiciary is overreaching itself. What about, the executive? Juvenile Justice Act. We dealt with a case where 34 girls were in a shelter home. They were raped on a regular basis. And when this came to light, the wife of one of the more important persons in the shelter home, his wife was a cabinet minister in the state government. And when we took up the matter and we told the police, what are you doing? The cabinet minister was absconding. They said, we can't find the cabinet minister. Can you believe it? We said, well, what is this going on? How can a cabinet minister be, you don't know the whereabouts of a cabinet minister? Ultimately, after about 10 days or something, they found that cabinet minister and took action. But now look at it from the checks and balances point of view. We had material before us that neighbors in that shelter home, neighbors, surrounding that shelter home, used to hear screams at night of these girls who were either drugged or being raped or abused, whatever it is. But they were so scared that the neighbors did not complain. They were scared of whom? They were scared of the police. They were scared of the persons who were running the home. They were scared of the wife of one of these persons who was a cabinet minister. They didn't have the guts to complain. And 34 girls were being raped. POXO, prevention of child sexual abuse. A good law, 1.6 lakh cases are pending of children who have been sexually abused. Now you can imagine what will happen to them when they grow up. What kind of people are they going to be when they grow up? Waiting for justice. And when the court says do something about it, overreaching yourself. That's not your job. Your job is to decide cases. Well, if there are so many instances going on and there's so much happening, what is the state doing to support the judiciary to decide their cases? Construction workers, 30,000 crores have been collected over the years for the benefit of these construction workers, not given to them. So you still have construction workers who are living in shanties. We asked the construction worker welfare board, what is the money being used for? They said, oh, we are buying washing machines. Huh? Half of them don't even have proper clothes to wear. We are buying laptops. Laptops for whom? For construction workers? What are they going to do with laptops? So you have laws which the state does not implement. So when you talk about the theory of checks and balances, let's not look at it only from the point of view of the judiciary coming under attack, of crossing what they say is the Lakshman Rekha, of going overreach and so on and so forth. There's a different dimension to it also. The second category of cases is the failure to enact social justice laws or laws which impact people. The legislature, checks and balances. What about checks and balances on the legislature? We are signatories. India is a signatory to CEDAW, the Convention on Elimination of Discrimination Against Women. Signed sometime in the 1980s, ratified in 1990, not implemented. No law made on the basis of the convention. The Supreme Court says in 1998-99, in the case of Vishaka, you cannot permit sexual harassment of women at the workplace. If you are not legislating, we are laying down guidelines. The Supreme Court was accused of legislating. Who are you to legislate? The Supreme Court was told, well, Supreme Court is not anybody to legislate, but what about you? You are the ones who are supposed to legislate. Are you legislating? If you are not legislating, then what is a citizen supposed to do? Supposing a woman is sexually harassed at the workplace, what is she going to do? She will say there's no law to protect me. Parliament is not enacting a law. The Supreme Court is saying that no, we have no jurisdiction. But what happens? Is it a free for all? For anybody who wants to, sexually harass a woman at the workplace? Then yeah, you can go ahead do whatever you want because there is no law. All right. Medical termination of pregnancy, it's a huge issue. I'm sure in many of the high courts in Kerala, Tamil Nadu, Karnataka, Andhra, Telangana, cases would have come of women who are wanting an abortion for a variety of reasons. We've dealt with this in the Supreme Court also, of a 13 or 14-year-old girl who was raped by her uncle and she became pregnant. And 20 weeks had gone by, that is the limit. Doctor said, sorry, we can't perform an abortion. So what happens? This 14-year-old girl is supposed to carry the child of her uncle who has raped her. There are many such instances which you would have dealt with in the courts, in the High Court over there as well. There is enough medical evidence to say that 24 weeks is safe. One is because of there could be some incurable mental ailment or something. It will show up only after 20 weeks. But if you stick to 20 weeks, the abortion cannot be performed. So the person has to come to the court. So you have all kinds of problems, of women who are raped, of women who are carrying a fetus, which they know what is going to happen when the fetus is born. But the change from 20 weeks to 24 weeks has been discussed now for the last 2 years, but legislation has not been enacted in spite of scientific medical evidence. Human trafficking, a very, very, very serious crime. We are still depending upon the ITPA, Immoral Trafficking Prevention Act of 1956. It's how much? 64 years or something? We're still depending upon a 64-year-old law. We are depending upon Section 370 of the IPC, which talks of slavery, virtually slavery. I don't think anybody in our country will admit, certainly the government will not admit, that there is slavery in India. But that's what human trafficking is supposed to be. And that's what 370 says, 370 IPC says. Again, we are not enacting a law. What for? What about checks and balances on, the legislature? Now you have instances of cyber crimes, cyber trafficking. I was with some people on 30th of July was the International Human Trafficking Day, Anti-Human Trafficking Day. 40 girls in one state were trafficked. They were asked, who is the person who is responsible for your trafficking? It was all done through, cyber trafficking. They all said one person by the name of Raju. Now, subsequent events showed that somebody comes, he doesn't show his face, ask him his name, my name is Raju. It could be 40 different persons, all having the same name. It's a nexus, it's a gang. All of them say, my name is Raju. The face is not visible, it's all on the computer, right? Name is fraudulent. How do you catch a person like that? 40 girls were caught, while they were being trafficked. And they all gave the same story that it happened over the internet. Can we not have a law for that? Are we actually, is our legislature actually thinking about it? How to curb this kind of a crime? You have missing children, 3,856 missing children between 2010 and 2014. What are the laws with regard to that? So you have these, instances where I think it is important that we need to expand the scope of understanding of checks and balances, and these are, some issues that keep coming up before the courts in public interest litigation. Third category, where there is no law that exists, absolutely no law. I gave you examples of CEDAW, which is an international convention. I gave you medical termination of pregnancy, there is an act. I gave you an example of human trafficking where there is an act, IPC and ITPA. But you have instances where there is no law at all. We dealt with the case of widows in Vrindavan, life of dignity. They have no money. How do they get their breakfast, lunch and dinner? They have to go to a temple and they sing bhajans. And the temple authorities give them some food, which is their breakfast, which is their lunch. Then in the evening they go, they sing bhajans again, perform aarti, and they're given their dinner. Where do they stay? They stay in a dharmshala, where the conditions are horrible, and they're virtually beggars. no law at all to protect them, no law at all with regard to Article 21 and life of dignity. Fortunately, the one officer in the government took tremendous amount of interest in this and took steps to get them at least a decent accommodation, if nothing else. Prison reforms, no laws on prison reforms, on prisons, nothing. So you have suicides in prisons, you have persons being beaten to death, torture. Supreme Court says that even prisoners have got fundamental rights. Do we have a law in that regard? We don't have a law. So all kinds of things are happening in prisons. People come to the prison, they have a cell phone. You can get drugs in the prison. How does that happen? Where is the theory of checks? Is there no check on the police and the prison staff? Is there only a check only on the judiciary and on nobody else? Fake encounters. You had one in Hyderabad recently. You had one near Kanpur recently. You have many of them in the Northeast, I can tell you that. Many of them. Is there a law? Who is to investigate? How are they to investigate? Even the Supreme Court doesn't have confidence in these kind of investigations. So, for the Telangana thing, Telangana fake encounter, they appointed a retired Supreme Court judge to preside over a committee to find out what happened. In the fake encounter near Kanpur, the Supreme Court appointed a retired Supreme Court judge. How does one check the police in a situation like this? Where is the theory of checks and balances? Does it not apply to the police? And what will happen? The committee will give a report, all right, prosecution will be launched. God alone knows when the decision will come. God alone knows who will be the witnesses. They might be from the police, and the police will make sure that they turn hostile. Where is the system of checks? Where is the system of balances? Unorganized sector. They say that 90% of the workers in the country belong to the unorganized sector. I can tell you about brick kiln workers. We had to deal with one such case. They were told that we are going to take you to, at that time, Andhra Pradesh, undivided Andhra Pradesh. But they were being taken to Chhattisgarh. When they realized what is happening, they are going to a different place altogether, they tried to run away. 2 of them were caught. The contractor tells them, he says, I'm giving you a choice. Do you want your leg to be chopped off or do you want your hand to be chopped off? That is a choice the contractor gave them. Eventually, the hand was chopped off. When we talk about access to justice, where are these people going to get access to justice? When we talk about checks and balances, who is going to check people like this contractor? Who is going to check the police? Is it that the judiciary should only be in the firing line and nobody else? This is where public interest litigation becomes very, very important. And we cannot say that, judges are going haywire, passing all kinds of orders in public interest litigation. Well, if the executive does its job properly, if Parliament legislates in time, there will be no public interest litigation. Why should there be public interest litigation? The fourth category is where a creative interpretation is required from the courts in understanding laws and bringing them, in the context of society today. The transgender community, for example. The Supreme Court gave a very creative interpretation. Our fundamental rights, part 3 of the Constitution talks about persons and talks about citizens. In the Nalsa judgment, Supreme Court said that transgenders are persons. transgenders are citizens. So they are entitled to the same rights that all of us have. That is creative interpretation. You can call it judicial activism, but it is creative interpretation. You have section 377 of the IPC, consenting adults. Oh, what are you doing? Overreach. But that's creative interpretation. And why should there not be creative interpretation? Is there a law which says that laws cannot be creatively interpreted? If that was the position, we wouldn't have had judges like Justice Krishna. They would have been impeached long time back for giving a creative interpretation to rights and laws. We dealt with issues of child marriage. If a minor gets married, sexual intercourse with her is permissible. Why is that? And so therefore you have child brides. And young girls are sold in marriage so that somebody can exploit them. I read an article fairly recently about a girl from Tripura, one end of the country. She was probably sold, but anyway, she was married to a person from Rajasthan, the other end of the country. She was taken to Rajasthan. She lived with that man and became pregnant. After some time, she got some courage or an opportunity, managed to run away from the house, and she was roaming around in Jaipur. That was not the city where she was living, but she was in Jaipur. The police caught her wandering around. They took her to the police station and she narrated her story, whatever she could. The police did not know what to do. How are we going to send her all the way to Tripura? There's no train going to Tripura, so she will have to go by air. Who is going to pay for it? Who is going to sanction it? So they have internal checks, they have internal balances. Where is the money going to come from? Who's going to answer all the questions? I happened to read this article. I rang up the Chief Justice of Tripura High Court. And I told him, I said, this is what has happened. She's a girl from your state. Fortunately, he took it up as a public interest litigation. And the Child Rights Commission decided to pay for her airfare and brought her from Rajasthan to Tripura. The mother said, I am not taking this girl back. That leads me to suspect, of course, you can't be sure, that she had sold off her daughter in marriage, so-called marriage. And if she takes the girl back, those people will come back and say, well, return our money. This is where, we have to look at many of these issues in a broader sense. And let's not just say that, well, the theory of checks and balances applies to the courts, it doesn't apply to anybody else, it applies to everybody. Whether it's the legislature, whether it's the executive, whether it's the press, the fourth pillar, and of course the judiciary. So I believe that public interest litigation is absolutely necessary. We need to have public interest litigation. Why? Because we have problems which are quite peculiar to our country. They may not be there in other countries. They may not be construction workers, cess and all that may not be there in other countries. I don't know. But we have 30,000 crores that has been appropriated but not given to them. We may not be having child brides in many other countries. But we have a problem. Now, the courts do sometimes exceed their jurisdiction. I will not say that every public interest litigation the court does the right thing. No, it doesn't happen. There are cases where the court has exceeded its jurisdiction. That's all right. But there are cases where the executive has exceeded its jurisdiction. Why don't we criticize the executive for that, for overreach? Transfer orders are passed at whims and fancies. People are dismissed at whims and fancies. That's not overreach. Laws are passed which are unconstitutional. That's not overreach. So mistakes occur. It's not only that the judiciary makes a mistake, it's not only that the judiciary passes an order which should not have been passed. The executive does that every day. Most of the cases in the courts are against the government, whether it's the central government or the state government. And most of the orders that are passed are quashing the orders passed by the executive. That is overreach. Now, it's all right to say that, judicial activism, why are you striking down our orders? But who asked you to pass illegal orders? If you pass illegal orders, what is the citizen supposed to do? Say, all right, I'm quite happy the order is illegal. There's nothing I can do about it. Courts won't come to my rescue. So illegalities will perpetuate. If Parliament passes a law which is unconstitutional, impinges upon the state list, what is going to happen? The state is going to say, all right, it doesn't matter. You violated the constitution. Or if the state legislature passes a law which is within the domain of Parliament, is Parliament going to keep quiet, or the central government, is it going to keep quiet? And say, no, it doesn't matter. So overreach, judicial activism, you can convert it. Call it executive overreach. Call it legislative overreach. Call it executive activism. Call it legislative activism. These things happen. That's why we have checks and balances, to make sure that nobody goes beyond their limit. That's why we have appeals. That's why we have review petitions. So if the High Court passes an order which is going beyond its jurisdiction, the Supreme Court will say, well, you can't do it. If the Supreme Court does it, there's a review petition, there's a curative petition. The case about this LGBT community, Section 377, what happened? It came about as a result of a curative petition. So the Supreme Court realizes its mistake and it corrects it. Can't the executive do that instead of blaming the judiciary for overreach? We have to think about it. I will say definitely that courts have to be circumspect. There are certain areas where the courts do not venture. Foreign policy, that's not the domain of the court. Movement of troops, whether troops should be stationed in Ladakh or whether they should be stationed somewhere else, this is not the jurisdiction of the court, surely. But almost everything else would fall within the jurisdiction of constitutional limits. And if there is a transgression of constitutional limits, the courts must interfere, and they will interfere. And let's not call it, by some fancy title of activism and overreach and so on and so forth. Crossing the Lakshman Rekha. Executive crosses the Lakshman Rekha. But nobody says, no, you see. What is the executive doing? How does one check? Sometimes, of course, it's a matter of self-restraint in the sense that the courts have to be careful that they don't entertain each and every kind of public interest petition. It is not that, just because a petition has to be filed, it has to be entertained. No, it's not like that. There are persons who come because they have a hidden agenda. The courts have to be careful. There are persons who come to the court on reading a newspaper. Morning you read a newspaper, afternoon you file what you call as a PIL. It can't work like that. There are persons who say that, oh, my name has come in the Limca Book of Records as the person who has filed the most number of petitions, public interest petitions. There's one person, he is styled himself as some public interest litigation man or something. Some title has been given to him as having filed a very large number of public interest litigations in the last 5 years. He claims that he has filed the maximum number of litigations in the last 5 years. There are some who said we have filed more than you in 10 years. So now these kind of people have to be checked. There is no doubt about it. They are a nuisance. And the courts have enough powers to prevent this misuse. So locus standi, while it has to be broadly construed, and I think it should be broadly construed, the courts have to be circumspect, they have to be careful and ensure that they're not going to entertain each and every case that comes before them. We have already discussed locus standi. You can't have anybody just walking in. It must be a person who has the public interest in mind and not his name coming in the newspapers or his name coming on some website to say that this person has filed this petition. Many of them do it because they want their names to come in print. But there are many people who are genuine, who have genuine public interest. Starting from the time of S.P. Gupta. What interest did he have? A senior counsel with a lot of reputation, a lot of work. V.M. Tarkunde, great lawyer, human rights activist. He doesn't want publicity. S.P. Gupta doesn't want publicity. Swami Agnivesh doesn't want publicity. So many of them. But just because of a few, let us not denigrate the entire system of public interest litigation. Let's not denigrate all the lawyers who come for public interest cases or litigants who come for public interest cases. Just because there are a few cases in which the courts have passed orders which they should not have passed, you can't say that the entire system is bad. Public interest litigation should be thrown out. Public interest litigation has worked wonders for disadvantaged people in India. And it is being followed in Bangladesh, it is being followed in Sri Lanka, it is being followed in Pakistan, it is being followed in Nepal. All these countries can't be completely wrong. And where have they got it from? They've got the idea from us. So my view is that when we talk about checks and balances, let's talk about it in the context of public interest litigation. Let's talk about it in a reasonable manner. Let's look at it from a positive point of view. Yes, mistakes happen. Everybody makes mistakes. I mean, you can't say that nobody makes mistakes in this world. Let's get along. Forget those mistakes. Learn from our mistakes. Make sure we don't repeat them. That's all that I would like to say. Thank you very much.
Thank you very much, sir. From Superman, Spider-Man, and all other men, we have now Pillman and Salman coming in. Maybe that is a curse of the present generation, but still, sir, the way in which the courts are scrutinizing public interest litigation as if it's some sort of publicity stunt.
Yeah.
To a certain extent, I believe, sir, it's counterproductive. Let us forget about the person who's exposing it, but the issue has to be looked into. I believe that's it. Sir, we would like to have the comments from the person responsible for getting you, sir, onto this platform. That is Justice Cotton Ram, sir. Please, sir.
Sir, as usual, your presentation is thought-provoking. Only one question which keeps troubling me is that the implementation with respect to the orders that are being made by the courts and who is to bell the executive. I'm not talking about the political executive. I'm talking about the bureaucratic executive who are required to implement the orders. When they have become so subservient to the political executive, and the political executive is the one which controls How do we deal with it?
Yes. You see, this is something that I realized when we were dealing with, the rights of children. We have talked about continuing mandamus in one of the judgments, maybe in two judgments, we've talked about continuing mandamus. You see, one thing is that, you say that, all right, this is the direction that we have given to you, implement it. Okay, and then we forget about the case. It doesn't work like that. We had a case about, where there is sterilization of women. Directions had been given by the Supreme Court way back in 1987. We dealt with the identical issue in 2016 or 2017. Identical issue. The mistake that was made in 1987 was that the Supreme Court gave directions, very good directions, which we reiterated, very good directions, but there was no follow-up. So, well, maybe for 1 month, 2 months, 3 months, the bureaucracy implemented those directions, and after that forgot about it. So the answer to your question is continuing mandamus. Make sure that your directions are being followed. And I don't think there's any vicious bureaucrat that we have in our country. There may be some bad apples here and there, but nobody is vicious. And if you tell them that, well, this is a direction, it has to be followed, they will do it. It may take them some time, but they will do it. But that continuing mandamus is absolutely important. And that's the only way, we found from experience to make sure. In Manrega, people were not getting their wages. We said, why? You tell us how many people are there. Today there are 50,000. All right, tell us next week. Next week it comes down to 40,000. Third week it comes down to 20,000. And then it comes down to zero. But if you say, all right, you pay all these 50,000 people, give them 4 weeks time, it will never be done. So you have to have that continuing mandamus. It's important.
Correct. Sir, before we go to the interaction with others, we would like to have the academician's viewpoint. Professor Kaul is here. And before I ask him to open up, may I just put one question, sir? We were taught from kindergarten that the country stands on 3 legs: the executive, the legislature, and the judiciary. Is Pill and Sal an acknowledgement that the other 2 legs have failed?
The other 2 legs being what? The press, media?
No, absolutely not, sir. Executive.
Oh, okay. Yeah.
With the
pillars.
No, yeah. The other 2 meaning out of the 3. Yeah. No, I don't think so. But like I said, there are instances, where legislation should have been enacted but has not been enacted. There are instances where legislation has been enacted but has not been properly implemented. So, to some extent, yes, there is a failure. But then look at it from another point of view. How do you explain, cases remaining pending for years together? Somebody is told after 20 years that, listen, you are innocent. The other day, somebody was mentioning about a person who was in jail for 25 years, applied for parole, and it was not granted. Now, 25 years is such a long time, and parole for what? Parole for the purpose of going for the cremation of his father or mother or somebody in his family. Now, when you have instances of this coming up, after 15 years you're told you're acquitted. There are cases, I can tell you of a case which was presented in one of these regional conferences of the National Judicial Academy. Criminal case, 94 adjournments granted. No reason given, 94 adjournments granted. Followed by 113 minus 94 is what? 19.
19.
19 adjournments granted for framing of charges.
Oh, trial court. My goodness.
Trial court, yeah. 113 adjournments, out of which 94 without any reason, 19 also without any reason, but for something like framing of charges. How do you explain that? What about victims' rights? Do we ever discuss that? So yeah, I think the whole thing needs to be shaken up. You know, the bureaucracy, the judiciary. There needs to be a shake-up.
Absolutely, sir. Single panacea is not available. All the stakeholders has to be there.
Yeah.
Call, sir, your take on it.
Well, I came after many days because Justice Lokur was here, so I thought this was a good opportunity to again join and learn about the areas that he has. In fact, he has been in the social justice bench in the Supreme Court and the wonderful work that they have done. And I think he was in also that continuing green bench.
Yes.
That was also the part of the work that Justice Lokur again very wonderfully did. But I think primarily I would say that the evolution of the public interest litigation was primarily because the Supreme Court, after the ADM Jabalpur case, found that they have to find new ways and means to earn their legitimacy. And I think this was a very wonderful jurisdiction that they thought was to be developed, and they very heavily developed this jurisdiction, though it development of the rights of the underprivileged and the weaker sections of the society, because those people who could not have on their own access to the court, Supreme Court opened up and kept the doors ajar for these underprivileged and people who could not reach the court to enforce their fundamental rights. I think 2-3 cases which I would like to say here are very, very important. I think one of those cases which I mentioned earlier also in one of my presentations here was Salal hydroelectric project, where it was a question of the migrant labor. And if we had really seen what Supreme Court did in that judgment and enforced the rights, raising the rights of the workers under the Minimum Wages Act and other provisions of the Act to the fundamental rights. And that was also in the assured workers case, where the Supreme Court again talked about violation of provisions of Minimum Wages Act amount to begar, where they said employing children below in hazardous employments like construction was violative of the fundamental rights of the children. I think we had an opportunity in the Supreme Court recently where the Supreme Court should have, either on its own or when some people went to the Supreme Court for enforcing the rights of the migrant workers, picked up those areas and developed further jurisprudence in this country. But I am happy at least recently Supreme Court has again realized that on its own it took a suo moto cognizance of certain rights of these people. And yesterday I read one of the judgments of the Supreme Court, Gujarat Mazdoor Sabha, where they have come back with the same force that you cannot take away the basic rights of workers, and that notification which was issued by the state of Gujarat in suspending or not making applicable various provisions of the Factories Act has been questioned on the grounds where the Supreme Court has earlier done a good job. I think over the period of time you can see Supreme Court did not stop only at the rights of the underprivileged. They also went to enforce the rights of the people, right to life. You see, the environmental jurisdiction came mostly, if you see MC Mehta's work or the Supreme Court's best work that we can see is in the areas of the criminal jurisprudence, in enforcing the rights of the under trials, in enforcing, you have to see that, what is that, those cases that is a Khatun, Hussain Ara Khatun. You have to see Hussain Ara Khatun 1, 2, 3, 4, and then you have to see how the Supreme Court brought in that bail provisions had to be amended. We had to amend the provisions of the CRPC, where we had to bring in those people who cannot afford to give surety within 1 week shall be treated as indigent, and they will be given bail on the basis of their personal bonds. And 436A, which was basically Hussain Ara Khatun, which comes into the Criminal Procedure Code. And then it also goes to the lawlessness by the state. Then it goes on to issues of the governance. Then it goes on to the issues of translating socio-economic rights into the fundamental rights. But there are limitations in what court can do. It can only read them as fundamental rights, but to enforce those fundamental rights, you have to bring in the law, which the parliament has to do. And if the parliament does not do that, and that is where I think Justice Lokur has very beautifully drawn those 4 heads under which we have to see what is, inaction on the part of the legislature, or half-hearted action on the part of the legislature, and inaction on the part of the executive. And if the court has, in certain cases, given directions, it is because there was either no law, because that was an unoccupied area, or wherever it found that there was a law, there was no enforcement of the law. Therefore, the continuing mandamuses that were issued by the court from time to time. And only thing that court, I think, has always to be cognizant of, that it has neither the purse to enforce its orders nor the sword to ensure that its orders are, enforced by the executive. But I think that Justice Lokur has given a very wonderful suggestion to the Honorable Supreme Court and High Courts that they should not leave the case at some point of time. They should continue with mandamuses, which must be overlooked, and they must be enforced. Orders must be enforced till the last word about the order is spoken by the court. I think it's a very wonderful jurisdiction because it has taken India much ahead. And you find election law, you find RTI are all basically, these are all contributions that have been made. And that is what has given pride of place to our judiciary. And that's why it is considered to be Supreme Court of India, is considered to be the most powerful court in the world. And I'm sure that in future also our Supreme Court will do the work in the same spirit and zeal in which it has worked in the previous years. Thank you very much, sir.
Call, sir, wonderful. Thou shalt not legislate, but we'll see to that the legislation is properly carried out. Wonderful, sir. Ramkumar, sir.
Thank you, Shyam. Excellent articulation on the checks and balances in the context of public interest litigation and social action litigation. It was rightly said that it was the lawlessness in various spheres of human activity and the insensitivity shown in the implementation of the existing laws which necessitated the curial expansion of the jurisdiction. It was indeed the executive and legislative inertia, indifference and inaction which rightly said paved the way for devising easy access to justice to the underprivileged class of persons. Notwithstanding occasional straying into publicity-oriented litigation and private interest litigation and self-aggrandizement actions, this is a jurisdiction which had to be forged by the apex court with the noble objective of rendering justice to the downtrodden sections who were so feeble that their voice could not be heard. Compared to the malaise in the governance, in the lawmaking, in the governance and in the lawmaking areas, instances of judicial activism or overreach or adventurism are not so appalling to the system in which we live in. As rightly cautioned, courts also have to be circumspect to ensure that they do not cross the Lakshman Rekha. Wonderful lecture Wonderful lecture, sir. Thank you.
Ramkumar sir, wonderful. Somebody was asking in Gaza Strip, why don't you compromise? The answer was, I'm ready to compromise with my wife, but not on my wife. Private interest litigation and public interest
Yes.
litigation. Thank you, sir. Ramashan sir.
Only compromises, no compromising positions.
As simple as Justice Lokur is. The presentation was also simple but strong in making his opinion clear. Really, sir, the public interest litigation, sometimes though it is being misused, and the Supreme Court and the High Courts are also laying their hands where it found that it is a misused one. But the necessity of public interest litigation to have free access to justice is a necessity for the present day situation. See, but for the intervention of the Supreme Court, I don't think that the rat hole mining in the Northeast would have been exposed. And compensation has been paid to, because I am sitting in the Green Tribunal, in the Green Tribunal. That is only by virtue of the decisions of the Deepakumar's case. The mining, the activities have been regularized to some extent, because monitoring has been done by the SIA and other people. And similarly, ragging is an area where the menace of ragging was not known to the people at all. But for the Raghavan Committee appointment, the Constitution of the Raghavan Committee, getting the views on that, only is thereafter directions, because in spite of the fact that most of the states have not framed laws, only few states have framed laws. I do not know how far it is effective also, because as Legal Service Authority the act we are doing with those things, we find that that is not so effective also in curbing the ragging activities in the colleges and other these things. But for the Supreme Court, directions are being given. For example, the Bandh. The law has not come so far to curb Bandh, but only when the Supreme Court said, we are not doing the legislation, we are doing it. Get the person, take the principle of res ipsa locata who called for the Bandh is responsible for payment of compensation for the lost cost. So in spite of that decision, but how far it is being implemented, how it is being done, and also for the MC Mehta's case and the Godavarman's case, forest and environment should not have been protected. Where the perpetual litigation, we can call it as perpetual jurisdiction, is being exercised by the Supreme Court for giving direction. Prison reforms, for example, the Lordship was doing a great work on that, and tracing the missing girls. That is also one of the areas where Supreme Court has given a lot of directions, whereby to some extent at least the enforcement agencies have been alerted to be more careful in tracing those persons and bringing them back to their homes. So these are all the areas where the importance of public interest litigation is being exposed. And without that, I don't think that the migrant laborers and the construction labor, where the Lordship has given direction as to what the fund that is being used, where the funds are going. Because a lot of amount is being there with the authorities. They do not know how, though provision says how it can be utilized, that is not being utilized at all. These are all the areas where, but for the directions given by the Supreme Court, I don't think that the executives who are expected to enforce it would not have done it. It's a great area where access to justice has become easy, but for the, thanks to our Justice Krishnayar and Justice Bhagavati, who have invented this letter petitions, etc., being entertained, I don't think that India would have gone to that extent to protect the human rights, and also because it become a pioneer, that is being, our judgments are being appreciated by the foreign courts also on these issues. Really good presentation, sir. Really enjoyable presentation. Thank you very much, sir.
Thank you. Thank you.
Ramashan sir, wonderful. Justice to the doorsteps and accessibility to everybody. Jayman, you got a question, please.
Sir, wonderful, sir. Sir, my question, I want a comment. It's not a doubt. I want a comment on your. See, one of the main tasks in public interest litigation or the litigants are the delay in the results. You know, it's overflowed. The courts are overflowed. Even our lower courts, and second aspect is that expenses for that. You coming to Supreme Court invoking 32 or even 226 in many states because of the distance and all. it's a problem. So there was a suggestion, in fact, earlier, whether it was a serious suggestion or not, I am not sure. Why can't we give powers to district judges also, to certain extent, to entertain public interest litigations? Not on all, not you cannot, we can't say that, or to enforce the fundamental rights, etc. You cannot give right to the power to district courts, but still
Why?
to
Even
face
226? Even 226 powers can be given.
see, that's all. Yeah. Anyway, 226 can be also. See, I am not on that. Mainly, see the issues. Suppose a local issue. Suppose some particular district is facing an issue. You know, you are very well aware of. You are in socialist benches. Endosulfan issue. You are aware of that judgments on that. Supreme Court interfered and gave compensation. So that pertains to a particular district of Kerala. So such issues were there. They are not, most of them, some social activists involved, then some lawyers involved, then they are coming to Supreme Court. It's happening, fortunately, but still there are enough issues are there, which cannot be, because of their remoteness or poverty or it's not coming out. So what about thinking in this line? Why can't we give powers to district judges also? I'm just asking.
Yeah. You see, of course, if Parliament agrees, powers can be conferred upon the district judges. That's not a major issue. But you see, there are laws which are available, but which are not being utilized. Now, you may recall this case of Ratlam municipality. Right, where Justice Krishna gave a wonderful judgment on, pollution, water pollution and stinking drains and so on and so forth. That judgment was the result of a petition that was filed under Section 133 of the CRPC for an executive magistrate. The broad facts were that in that locality, there was a drain where all kinds of acid and everything was being put, all kinds of things were being put, and the place was stinking. And the residents of that area, the people in that area, they said that, listen, this is a nuisance under 133 CRPC. And the executive magistrate agreed. High Court did not agree. Supreme Court agreed with the executive magistrate. So you have laws in existence. Unfortunately, we are not using them. Now, why are we not using them? There are two reasons why we are not using them. One is that if you go to a court, trial court, or a district court, it takes time. Right? And everybody wants quick results. So, if you go to the court, it's going to take time. There'll be recording of evidence, this, that, and the other. Why go to that? Let's file a writ petition. It's much cheaper. It's much faster. You get an interim order very quickly. The result is that many of these issues which are there in public interest should, in my view, be tried first in the trial court. But they're not being done for these kind of reasons. So, I think if our people are more educated, if the lawyers, have greater confidence in the trial courts, a lot of these cases can be resolved at the local level.
So absolutely, sir. I mean, this coffee vending machine syndrome, wherein you put the coin on top and you require the coffee immediately beneath, might be the reason.
Yeah.
Absolutely, sir. Sir, regarding Coordinator, sir, are you there?
Yes.
Yeah. Regarding civil court's right to declare a provision to be unconstitutional, sir.
You have to refer it to the line.
I just forget the name. In Supreme Court, 1969 Supreme Court, while deciding Section 9, scope of Section 9, had said in that judgment, a constitutional bench, that the civil court has power even to declare a provision of law also as unconstitutional. The powers of the civil courts are wide enough. That's a classic case. In fact, added to what the Justice Lokur said, There are number of provisions under the CPC as well as in CRPC and also various enactments where basic injunctive reliefs and also mandatory injunctive reliefs can be obtained as just like the Specific Relief Act. After the Constitution came, 226 has come, but earlier all these provisions of 226 were virtually in the civil courts jurisdictions. Only that, as they said, the so-called speedy aspect, and then many a time the lower judiciary officials not being either encouraged or being restrained both ways with respect to by the higher courts and the higher judges or their administrative judges. They're always under that, they hold themselves. Otherwise, it would be a case where every time there can be thing. I have one other aspect, maybe it's a slightly contrarian thing. I'll just, probably Vijay wants to ask something, after that I will...
one more area. So one more area where the Human Rights Act provides for the human rights courts of district level. So none of the courts are being established so far. Yeah. In spite of the fact that the act came in 1998 or something like that. So far no courts have been in the district level. So suppose that courts have been established. Probably to some extent all these issues could have been looked into by the district court itself.
Correctly remarked by Stephen Matthew. Like district court is also a human rights court. Absolutely. Vijay.
Thank you, sir. Thank you for...
Yes, I remember I'll ask that question before I forget again. Sir, it's only for Justice Lokur. I had occasion to, before I got elevated, courtesy Justice Lokur, who had persuaded me and he pushed me into this...
wonderful post. Yeah.
Yeah, a wonderful post. He had a very powerful argument in making me to accept. Leaving me all my good practice and also all the goodies. No regrets. He said at that point of time, if I remember right, in the powerful three pillars, political pillar has virtually is become it's a kind of crumbling or crumbled already. Bureaucratic pillar also has succumbed to them, and thereby the two pillars have become totally weak, and anytime the structure may collapse. The only other pillar existing, supporting probably the country's side, is the judiciary. If good people don't come into and sit there and do their bit and try to restore, this will also collapse. Then in that kind of society, your children will grow up. Good luck to you is what he told me. I couldn't sleep for 1 week. I went back to my senior and my uncle and discussed with him. He said that exactly what we said is 100% right. So you better accept. That's where I was lured into. Not only me, my brother Justice Bhatt also was another one. And all the 5 judges who were appointed at that time, they all had an excellent practice, probably much higher. And out of that, 2 of them were designated senior counsels. In fact, Justice Bhosle asked me, I can't imagine that senior counsels accepting judgeship. It will never happen in Mumbai. So my question now is, apart from that, in Godavaraman's case, see, I had occasion to do some case in Orissa about just before my elevation, about 3-4 months. Just by mentioning Godavaraman's case in one of the power plant which is about to start, just for the sake of 10 acres of land, which is supposed to be either there's a dispute with regard to whether it is falling within the forest or outside the forest. The stay was granted, and today that 1200 megawatts power plant completely became, it never got started, just it was about to get started. And the stay was granted by the High Court. 3 years, in spite of best effort, it was never vacated, and it continued. Thereafter, after hearing the matter, the judges kept it pending for about 3 years, 2 years or so. Finally, again, the matter went to Supreme Court. Supreme Court gave direction, and then finally, again, order has been passed in favor of that petitioner. Again, is the petitioner, which is a public interest. Matter carried to Supreme Court. Supreme Court again granted stay. In the process today, that 1200 megawatts power plant is that 5 crores per megawatt. 6,000 crores of the state has gone down the drain. And then when I tried to look into the Godavaraman's case, I found in Godavaraman's case, issue which was raised initially was one. And thereafter, in the creation of this green bench, the idea may be good, but in the process, without deciding the issue which was raised, thereafter it just continued. And there were only interim orders and interim orders and interim orders in Godavaraman's case. A joke was there that it was a Peresia. It was an excellent bench for the senior councils to get interim orders every time. What is your comment?
Yeah, you see, you're right. Godavarman was actually limited to forests in
conservation.
But the scope of that began to expand. When the Supreme Court defined what is a forest, until then the definition of forest was not there. It was not there in the Indian Forest Act of 1927. It was not there in the Forest Conservation Act of 1980. So when the Supreme Court defined forest as meaning anything which you and I would understand dictionary meaning of forest, that's when the scope of Godavarman got expanded. And since a large part of the country is forested, a lot of these issues came up. And one thing got intermingled with another. So industries would come up in forests. Mining, there's a lot of mining activity going on in forests. So yes, you're right. It did, become a very vast area, and that's why the Supreme Court also appointed the CEC, the Central Committee, Environment Committee, to assist the Supreme Court in arriving at a decision, where people began to make complaints. And because that was a body which was appointed by the Supreme Court and they had no concept of jurisdiction and so on, they started giving reports on a variety of issues. They did an excellent job. I'm not criticizing them. They did an excellent job. But then, you see, now, when I was there, ultimately, I think it boiled down to about maybe 4 or 5 major issues. A lot of the smaller ones got finished, but there were, I think, about not even 5, probably 3 or 4 major issues. Once those are taken care of, I think Godavarman will wind up. But yes, in between there was a huge expansion. I will not deny that. And we had some application on the other in Godavarman every day, Monday to Friday. But we had to deal with it, and that's why these 4 issues got narrowed down.
Sir, as we are running short of time, we'll take just 2 more questions. Navasjan, please put your question first.
Good evening, Your Lordship.
Good evening.
First of all, thank you very much for that engrossing and highly insightful session. And privately, I would like to make a small comment on your facial expression that you are more glamorous than our veteran Malayalam film actor Madhu. Take it. So, very pleasant, configuration. Special thing. So my question is, whether this public interest litigation has totally become a private interest litigation now, because in most of the cases, litigants have got highly vested interest, and interest at large, interest of public at large is missing. In most of the cases, they have made this as a business for their survival. And another thing is there is a category forming up in the society known as activists, public interest litigation activists, right to information activists, RTA activists and PIL activists. So do we really need such activists? If I need to know certain information, I am free to approach the public authority in the proper manner and obtain your information. Why should someone else come to me and say that I will get all this information from you, you take money? One can understand whether if it is a lawyer who is specialized in RTI or is specialized in what you call public interest litigation. But when it comes to a private person and they are being glorified as activists, they come into media in the evening for the evening talk, saying that they are having some specialized knowledge on RTI and PIL. I feel personally that if those great souls, Justice V.R. Krishnaiyer and Justice Bhagavati, being still on the bench, they would have certainly come out with certain new rulings. Now, if we really balance it, whether the pros and cons, which is more, whether it is a boon or bane, which is more, I feel it is in the negative. Sir, another thing is, with regard to the excessive encroachment of the media these days, even a minor criminal case becomes a matter of public interest, because by evening they will expose everything. So, whether it is public, the term public interest needs to be redefined. And similarly, some filtering mechanism has to be brought into the RTI also. If I am not very much concerned about an information which is totally irrelevant for me, and I am using that information for making money for my personal gains, is it not the abuse of the process of law, sir? These are the two things, sir. But you have taken us through POCSO, you have taken us through different sections, different statutes, and you have compared, you have of course made a checks and balances study. But my apprehension is with regard to whether it is a boon or bane, whether pros or cons, which is more on this side. Whether can we have a mechanism in the judiciary to put a check on the number of litigants?
Navasjan, sir, wonderful question. Over to you, sir.
The genuineness of the litigants.
Whether asking a knife is good or bad, it can be used for murdering and it can be used for saving a soul if it's held by the doctor.
Absolutely.
And cutting vegetables also.
It should be put to work. This is it, my lordship. Thank you very much.
Thank you.
Yeah. Good evening, my lords. Very powerful lecture. Checks and balances, normally we think that it is more applied to the judiciary. We have opened up our thought process that checks and balances are equally on both on the legislature and on the executive. Sir, I had one doubt. There was a query in the chat box also, saying that most of these public interest litigations are becoming infructuous with time because of lack of judges. Even with regard to tribunal, of course, there is an ongoing case with regard to being argued filed by the Madras Bar Association with reference to appointment of members to the tribunal with regard to certain schedules. I was only looking that there is also a case, I was told that there is a case with regard to appointment of filling up of vacancies in high courts also. There is this, for services, there is this model calendar which they follow back from 1998, where they have certain timelines which they are supposed to adhere. They are supposed to prepare a panel and send it across by certain time schedules are there. Can't we have something like that? Instead of, can there be a mandamus which can be issued like this, which could be a solution, one-time solution to the filling up of vacancies, where a certain end of the year, we create a panel, send it across depending on the vacancies, approval or selection. Something like that. Because
continuing matters. You mean continuing matters?
Yeah.
I'm testing.
No, not contesting. I'm only saying that there could be a panel which could be prepared just like a model calendar. DPC, DPC substitution is a collegium here. They could prepare a panel every year, something like a time schedules followed by the model calendar, so that we don't have the vacancies, abrupt vacancies. Suddenly we have more vacancies. At times we have this disparity would not be there. So suppose now in Telangana we have only about 13 or 14 judges. I think there are more other vacancies. This could be avoided if there is a mandamus issued as to filling up of vacancies like time with regard to time schedules.
Yeah, you see, time schedules have actually been laid down, in the second judge's case, but they're not adhered to.
More honor in their breach.
Yeah, you're right. You see, I will tell you, Justice Kodandaram will know about it. You will also know about it. I had made recommendations. The collegium had made recommendations when I was the Chief Justice in Andhra Pradesh High Court.
13.
13. Sorry?
13 number.
Yeah. But the time that was adhered, that has been laid down by the Supreme Court was not adhered to. The Supreme Court and the government took their own time to take a decision. I had asked, when I reached the Supreme Court, I had asked the person who was in charge at that time of the Department of Justice, what is happening? He said, no, the file is under process. Now the file remained under process, I think, for about 5 or 6 months or something.
No, 1.5 years.
1.5 years. Okay, there you are.
In fact, I came to yourself and requested I wanted to be relieved. And you said, I can't force you.
Yeah. So there you are, 1.5 years. And the Supreme Court had said that if a response is not given within a specified period of time, it will be deemed that the government has no objection. What happened to that deeming provision? Nobody knows. Even now in the present memorandum of procedure, there is a time scheduled, but not adhered to. So I don't know. It's you can blame the judiciary for not being firm. You can blame the government for not being firm. I don't know whom to blame, whom to say, but this is the problem which is perennial. My personal view is, and which I had in fact mentioned to the Chief Justices when I was there in the collegium, that if there is a problem, don't just send a letter to the law minister, or don't just call him up on the telephone. Have a meeting. What's wrong if you have a meeting? Sit across a table, decide face to face what is to be done, what is not to be done. In Andhra Pradesh High Court, we required money for many things, including that, that dome and all that. There was a lot of correspondence. I had one meeting with the then Chief Minister, Mr. Pratap Reddy. I think he was the Chief Minister. In one meeting, it was all sorted out. I didn't lose anything. He didn't lose anything. The High Court gained. So I think many of these things, that bureaucratic style of functioning, I will send you a letter and then you will reply with reference to your letter number so and so. I think all that should be obviated and there should be a face-to-face discussion, thrash it out one way or the other. It shouldn't take so long.
Because that is leading to a lot of delays and consequential...
Right, yeah, you're absolutely right.
Even I am told that it's because sitting in the green bench here, the green tribunal here, Telangana doesn't have the appellate authority under the Pollution Control Act.
Yeah, there you are.
So they are losing the power, the forum for filing an appeal. They will have to, because the Sterlite case said you can only go to the High Court. So we have no other option, but though second appeal is provided to the green tribunal, we cannot entertain bypassing the one tier.
Yeah.
That difficulties are also there because of the non-fulfillment of certain statutory bodies.
Yes.
Which they have to exercise their powers.
As far as members of tribunal are concerned, there is this public interest litigation by the Madras Bar Association, which is argued by Mr.
In spite of that, it's not being done.
Presently, it is being argued by Mr. Arvind Athar, where he has requested for 2 or 3 judges of Supreme Court to be on the panel, so that there can be a list of vacancies and a constant monitoring with regard to filling up of vacancies on a continuing basis. They wanted to make it like a permanent setup so that they can have a mix of the honorable judges and the executive to fill up the vacancies in the respective tribunals.
Now, another thing that has happened because of the amendment to the Green Tribunal Act as well as the Tribunal Act, the 2020 rules. most of the judges are not interested in coming for this, because by the time the process is over, the period is, they are getting only lesser period. That difficulty is also there on account of this. Those are all practical issues where if it is properly done, timely done, probably people may come. Otherwise, the difficulty will be by the time they will be engaged in some, they may be preferring for a job in their own area, or just like arbitration has become a lucrative practice for the retired judges, they are going for arbitration. They are not interested in coming for judicial work, though they want to come. If it is properly done, timely done, good people may come. That is not happening nowadays.
Absolutely. Sir,
Honorable Sir,
the topic is so good that we have Nawaz Jan waiting for an answer. We have Nitin with a question, but time constraints. I think it's already 5:15 rather like. Over to you, Prem.
1 minute, Shyam.
Yeah, sure, Vijay. Sure.
Just I don't pose a question. Honorable Sir, I remember Mr. Justice Kodanram always takes your name whenever we have any informal discussion, saying that it is because of Lokur I've become a judge. It's not that it's today that he is saying that. And if I, with my acquaintance with Honorable Justice Kodanram, I can say on both on good times and on and other times also.
Yeah,
Thank
but
you,
you are a good judge. Huh?
He is absolutely.
Yeah, so there you are.
The persuasive effect or persuasive capacity of Lokur sir, I mean, that's reflected by the radiance in the face of Kodanram sir. Prem, over to you.
Well, sir, it was an excellent articulation on the topic. And sir, as you said, this public interest litigation, as far as a country like India is concerned, of course, it can serve as a vehicle which rather creates or enforces the rights. And it is critical to the very sustenance of democracy. And we know that justice itself is a very indivisible concept. As far as India is a nation of seemingly infinite paradoxes. And pill, as it is often known, it is the most effective weapon in the armory of law to reach or to attain the social justice to a common man, as it plays a very significant or vital role in the very civil justice system. And it can achieve those objectives which could hardly be achieved through any conventional private litigation. And of course, true that there are bills which are filed merely for publicity, maybe merely for with vested political interest. And true, those type of waggish ones that should be discouraged. But so kindly see, the Supreme Court started commenting on the misuse of public interest litigations right from Dr. Duryodhan Sahu. That's a 1999 decision, wherein it was said that the service matters that cannot be pursued through the appeals. Then you have a 96 decision. I think it is Dr. Subbarao versus Parasharan. And of course, two rulings by His Lordship Justice Ajit Pasayat. One is in Neetu's case of 2007 and Ashok Kumar Pante of 2004. Then you have Justice Dalbir Bhandari in 2010, which is a very famous decision, Balwant Singh Chaufal's case, wherein the Supreme Court directs all the high courts all over the country to frame the rules regarding the pleas. And later on, you have Manohar Lal Sarma's case. It's a three-judgment decision led by Justice Deepak Mishra. And you have Justice Dhananjay Chandrachud's case in I forgot the name of the case that particular case. His Lordship Justice Dhananjay Chandrachud. True, sir, the court should not allow the process to be abused for oblique considerations. Of course, by what you call the mass phantoms who can monitor at times from behind, and some persons with the vested interest, they indulge in the pastime of meddling with the judicial process, either by way of what you can call the force of habit or from improper motives. And they would try to bargain for a good deal as well as to enrich themselves, as has been told by Nawaz Jan. But sir, my question is, aren't the guidelines which have been framed by the Supreme Court in Balwant Singh Chaufal's case, in Manohar Lal Sharma, in Ashok Kumar Pante, aren't these guidelines enough, or aren't these guidelines by itself, aren't these guidelines capable of weeding out those petitions which, even though titled as a public interest litigation, is in essence something Because the judges do have the judicially trained minds. Or do you still feel that we need more guidelines?
You see, we talk very often about judicial discretion and judicial restraint, right? I think it's only a matter of applying those principles of judicial restraint and applying those principles. Where guidelines will evolve, guidelines will change, depending upon situations. But I think the judges have to be alert to realize that, well, this is not a public interest issue, or it is a public interest issue which needs immediate attention, or this is a person who is just filing petitions just for the fun of it, to get his name in the Limba book of records. So a lot depends upon judicial discretion and judicial restraint. Non-interference in service matters, foreign policy, defense matters, and all that is a part of judicial restraint. So I think once the judges are alert and alive to, the case that is before them, we may not have these kind of aberrations. That I think is the, I don't think guidelines will make so much of a difference at the end of the day. It has to be, the judges have to be careful about it.
So, sir, but do we need any more further legislations by the legislature to check the filing?
It's debatable. It's debatable. My personal view is that it will not make any difference. It's debatable. What you're saying is, a debatable proposition, whether it should be there or it should not be there. But my view is that even if it is there, it will not make any difference.
Thank you, sir. As we come to the end of the 129th session, tomorrow in the 130th session, we have Senior Advocate of Bombay High Court, Majid Madan. He will be dealing with the topic criminal investigation, criminal trial. And please note the change in time because it's 11:30 morning tomorrow morning because the speaker wanted it to be in the morning and afternoon. Of course, we have been forfeiting the sleep of almost all the participants here. Tomorrow we'll let you sleep. So as we come to the end of the 129th session, let us first thank, it has been mentioned, if Justice Madan Lokur sir was responsible for getting Kodindaram sir onto the bench, it was Kodindaram sir who was responsible for getting Madan Lokur sir today's platform. So I'll first start the thanking Kodindaram. Thank you very much, sir. Had it not been for you, I'm sure that we would have been forfeited of this wisdom, the knowledge, the presentation today. Thank you very much. And sir, Madan Lokur sir, thank you very much for the presentation. We are enriched and the platform itself stands for Legal Empowerment Through Interaction Lecture Series. I'm sure that all the participants are empowered and to a certain extent enriched also. And the thinking pattern also is triggered. Ramkumar sir, as always, thank you sir for your valuable presence and inputs. Ramkumar, Ramakrishnan sir, thank you very much. And Paul sir, nice to have you back after hiatus, in the sense to see your handsome face again is wonderful. Thank you very much. And we do hope to have you in the platform regularly.
So we can make sure Devanand has come back.
I can take a cue from Madan Lokur sir of persuasion. I'm sure that I'll be doing that to keep you in this platform throughout. So thank you. Till we meet again tomorrow. Thank you very much.
Thank you.